My name is Steen. I'm the director of the Elder Law Program at Pisgah Legal Services. If I need to speak up, y'all just let me know. But I've been at Pisgah for close to 8 years now. I've done a little bit of everything that there is at Pisgah. I've started doing full-time domestic violence work, done housing work. Now I'm the director of the Elder Law Program, and happy to talk to you guys about a pretty important topic. Does everybody know about Pisgah Legal Services? Are y'all familiar with us? Well, so Pisgah Legal, we are a nonprofit law firm. We offer free civil legal assistance to low-income folks throughout Western North Carolina. Here is a map, sort of the service area that we cover. Honestly, it's probably bigger than this at this point. It seems like every time I check, we're in more places. These dark blue counties, we offer our full range of services. So that would include Henderson County, where you all are at. Some of the legal issues that we cover would include protection from domestic violence and child abuse. If somebody needs help with like a restraining order, if somebody needs help with getting custody of kids that are in a dangerous situation, we might step in and help with that. Prevention of homelessness and unsafe housing. A huge part of my work is as a housing attorney, helping particularly seniors find and keep housing that meets their needs and keeping them housed. Securing essential public benefits. We have a really robust benefits team that helps people with Medicare, Medicaid, food stamps, getting disability, Social Security, increasing access to health care, making sure that people can find health insurance, fraud prevention for seniors. That might be another thing that I could talk to you guys about. I give another presentation about the elder fraud industry and the scams that are going around, how to spot them, what to do about them, how to keep yourself safe. That's been a huge part of our work lately, and I know there's a lot of interest in that topic, so maybe that could be a future presentation. We help low-income immigrants achieve legal status and promote affordable housing and job creation, try to make some upstream changes. We also have what we're calling a Healthy Economic Opportunities Program, or a pilot, to help folks file their taxes. Low-income folks file for taxes. A lot of folks qualify for more tax credits than they realize. We're helping people get a child tax credit. If you're maybe like a grandparent who's taking care of a grandchild, you might qualify for some tax benefits that you're not aware of. Why civil legal aid matters. Like Jeannie said, I grew up in Western North Carolina. I was from here. I went 2014. When I was in law school, I came back to Pisgah to intern here. And even having grown up here, I was just not aware of like the staggering amount of unmet legal needs that are happening in my home. I would say, if you are, the way our system is set up, if you are charged or accused of a crime, our system guarantees you an attorney to help you with that process. If you can't afford one, a public defender is appointed to represent you. We recognize that you have to have an attorney to help you with something like that. If you are the victim of a crime, well, then the district attorney represents you. The state is your attorney for that. We recognize that you have to have an attorney to help you with that. But if you are a grandparent that needs help getting a kid out of a dangerous situation, you need to get custody of them. If you are a tenant and your landlord turns your power off in the winter or decides to throw you out, there is no free legal attorney guaranteed by our system. You are not entitled to an attorney to help you with any of that stuff. Just because it's civil doesn't mean that it can't be hugely important and can't really affect your life. The reason Pisgah Legal Services exists is to try and fill in that gap, because these are hugely important issues that you need an attorney to help you with. And so much of this stuff, even the ability just to get in the door, like to get in front of a judge, to ask for the relief that you need, you're probably going to need an attorney, much less to try and get the outcome that you're hoping for and to get the relief that you need. In North Carolina, there's one lawyer for every 554 people, but there's only one legal aid attorney for every close to 20,000 poor people. The need is absolutely staggering. But so to get into our topic for the evening, I have to do my obligatory disclaimer that I am an attorney. I am not your attorney. Without fail, somebody at one of these will want to ask me about their legal issue, or about they've got some crazy sister or some crazy uncle that they have got a question about, I would tell you to talk to your attorney. So nothing that I say here should be construed as legal advice. So there are three major documents that I want to talk about today to help you guys get prepared to get your affairs in order. The three documents would be the last will and testament, your durable power of attorney, and your health care power of attorney. I've also got a section about the most medical orders for scope of treatment. Some of you might have heard about that. I've decided to include that in there as well. By the end of the presentation, my goal is when you walk out of here, you'll know what this document is, how do I create an effective one, what do I do with it once I have it, and if I need to change it for any reason, how can I go about modifying it? And as Jeannie said, you guys are in the position where you can prepare and get these affairs in order. It's one of those things where it is never too early to start thinking about it, never too early to start it. I've had some very tragic cases where I'm going out to hospitals to help people put together their affairs in order. Young people, I had a guy that was like 45 that we had to go do an emergency will and power of attorney for. You don't want to be in that situation. You don't want to put your loved ones in that situation. I mean, it's a hard enough thing anyway without having to scramble to get this stuff in order at the last minute. But I will start with the last will and testament. So what is this document? This document, it allows a person, in the law we would call this person a testator, with legal capacity to direct how they want their assets to be distributed upon their death. Three little points here that I'm not going to get too in-depth on. I just kind of wanted to flag. I get asked a lot, what does legal capacity mean? They might have somebody that they think they created a will and that they're worried that maybe they weren't in their right mind, or that this person might not have the capacity to create a will. For our purposes, legal capacity to create a will is actually a pretty low bar. If you know what you have, you know who you can give it to, and you know who you want to give it to, that's probably all you need to create a will. And a lot of my clients, honestly, capacity sometimes is not an always there kind of thing. It's not an always never sort of situation. I might talk to them in the morning. They're perfectly lucid, sharp. Like, I feel like we could create a will, and then I go out to do it in the afternoon, and I'm not so confident. That's how it is for a lot of people. But if they had capacity in that moment to create the will, then they're good to go. Trusts, I'm not going to get too in-depth in those. By definition, if you are a Pisgah Legal Services client, your assets are probably not so complicated, your estate is not so complex that you might need a trust. Typically, we might, if you come to us and you need one, we might try to refer you to a private attorney or connect you with a private attorney to help you with something like that. And what about minors, wards, children? I'm going to touch on that a little bit later in the presentation. There are some things that you can do to flag for the court if you've got a minor child that you care for or a ward. So how do I go about and create an effective one? I've tried to, with this presentation, pull out actual segments from will samples that I use so you can see what they look like. So this is the first section here where you describe your family unit and define who is your immediate family. And believe it or not, that's probably one of the areas where I see people get tripped up or make mistakes. You might think it's simple to define who your immediate family is. Sometimes people will leave somebody off just because they don't want to inherit them. They think that if I don't include them in their will, that they're not going to, that's how you disinherit somebody. It's really important not to do it that way. You need to list as thoroughly as you can who is your family unit, who are the people that could plausibly inherit from me. What you want to avoid is a situation where somebody pops up after the fact and says, oh, they left me off their will. Obviously they weren't in their right mind. Like that. If they weren't sane, if they were, then I would have been in their will. So you want to be as thorough as you can in documenting who your family unit is when you go and create that. Be as thorough as possible. Know that in North Carolina, stepchildren do not automatically inherit from a will. You need to flag specifically that you want your stepchildren to inherit as though they were your biological children. So don't just assume that stepchildren would automatically inherit from you. If people have got questions, please raise a hand or interrupt me. I would rather talk to you than at you. Yep. Yeah, I can get. I don't have anything with me, but I can get something to Jeannie. Yeah, I can follow up, and I'll hang around afterwards if people have got would rather talk to me than share it with the group. Yeah.
So if you name your stepchildren, that's appropriate?
Yeah, that's all you need to do. You just want to make sure that, I have a child, a stepchild, who I want to inherit as though they were my biological child for the purposes of my will. But yeah, don't just assume that your stepchildren are going to inherit from you. You should probably put language like, I want them to be treated as though they were my biological child.
What if it's a blended family, his children, my children? When we do a will together or
Mhm.
whatever, our assets, if
Mhm.
something was to happen to us together,
Hmm.
how do we just list those children?
Yeah, well, I mean, you're going to do, I assume, separate wills, right? Yeah.
Right.
And just, you certainly want to outline who you want to inherit from you. If you want them to inherit as though they were your children, yeah, I would just say that. There's only one person in North Carolina that you cannot disinherit, and that is your spouse. Yeah. Try as you might. I have seen wills that try, but does not work. There's something called a spousal elective share in North Carolina. If you pass away and you have a spouse at the time, they're entitled to some portion of your estate. And if you don't make a provision for them in your will, usually that's how it works, that they'll just leave them out of the will. Rather than specifically try to disinherit them, but it's determined basically how long the marriage was. There's like a sort of guidelines for how much that spouse is entitled to. You can make bequests in your will. There are several different types. Specific and general are two of the big ones. Specific bequest, that's probably more like what you see in movies and televisions when you see people like reading a will out. Like, I want to leave my Joe DiMaggio baseball card to, like, my son. Like, you definitely can do that. That's called a specific bequest. If you want to be more general about it, you can do that also. Like, all of my personal property, I leave to X person. Some people like to structure it where my executor is allowed to kind of just distribute, this amount of property in whatever way he or she feels is fair and appropriate, rather than getting into, like, the nitty-gritty of it. Think very carefully about how you want to distribute your home or the real property. If you are somebody that's in a position where you have, let's say, a home or a piece of real estate, and you want to will that home to 5 people, like 5 children, don't do that. Would be what I would say to do. I see that a lot, and I typically think that it is a mistake, and to think maybe about a different way to do it. Your children may all get along, or whoever you're wanting to pass this property on to now, and I hope that remains the case, but it might not. And what happens when they pass away and now their 2 children inherit that 5th, it gets more and more complicated, and you're trying to sell the property and one of them doesn't want to. I would think about a different way to do it. Either once I pass away, my executor is going to sell the property and they'll divide the proceeds up among the 5 children, or I'm going to leave it to one person who knows what I want to have done with the place. I would think carefully before leaving one piece of property to multiple people.
Does North Carolina have beneficiary deeds yet?
Yes. I can talk a little bit more about that maybe after, but
Is it better to put one of your family so that have their name on the house, like you sold it to them or gave it to them, or?
There are different ways you could do it. You could do something like a life estate is what some people do, where like I'm basically going to deed this piece of property while I'm still living. I'm going to deed this piece of property over to my son. I'm going to reserve a life estate for myself, which means I'm allowed to stay there during my lifetime. And when I pass away, then my interest passes over to my son. There are a bunch of different ways you could do it. I would probably need to have a consult with that person to see what makes the most sense for their specific situation. But there are lots of different ways that you can structure this stuff.
So if you give it to one of your family, it would not go to probate.
Well, I mean, you can only give away what you have in your will. Yeah, yeah. So if you don't have it anymore, it's not going to go through probate. It's not a part of your estate if if you already deeded it over to somebody else. Yeah.
Oh, okay.
I get asked this question from time to time. Somebody will be a grandparent, maybe that has custody of a minor child, or has that child in their possession, or maybe you're a parent who has guardianship of a disabled adult. What can you do in a will? In a custody context, there's probably not much that you can do. You can certainly put your wishes about what you would like to have happen with this minor child in your will. A court can look at that. A judge can consider it, might even take it very seriously. But you can't really create like a binding custody transfer in a will. You're not going to be able to, parents, for better or worse, are presumed to be the natural custodians of a child. So unless you're like the sole parent, there's probably not a lot that you can do to create like a binding custody exchange in a will. It's a little bit different for guardianship. If you're the guardian of a disabled adult, you can actually declare what you want to have happen if you were to pass away. And the clerk handles guardianships. They're a special proceeding. The clerk is directed to take that very seriously, and they will give that a lot of weight. Choosing an executor. The executor is the person that is going to be in charge of administering your estate when you pass away. How do you pick one? What should you look for? Well, for one thing, I would say to appoint one person, sort of like we talked about with giving a house to multiple people. The law does allow you to appoint co-executors. I have seen that from time to time. I would not do that if you can help it. You can certainly pick a backup executor, like a secondary executor, but I would pick one person that you trust, that understands your wishes and what you want to have done with your estate when you pass away. If for some reason that person can't do it, is unable to do it, you can appoint a backup, like a secondary executor, but don't appoint co-executors. If they disagree, if there's a dispute about what to do, it can really jam up the administration of your estate. I get asked a lot, does my executor have to live in the state of North Carolina, the person that I want to administer my will? They do not. An out-of-state executor is okay. It's probably going to make sense to have somebody, if you're in North Carolina, to have somebody that, here that could do some legwork. There is some stuff that has to be done if you're an executor. There's a certain amount of running around and getting stuff together and going to the courthouse. Some people hire an attorney in North Carolina to be that agent and do that. But to answer the question, no, your executor does not have to live in North Carolina. If you've got a child or a family member in another state that you want to do it, that's okay. Yeah. Yes, an attorney could be your executor. It's really any adult that you trust can be your executor.
But you would pay them, but not a family member.
No, typically, I've put here too, serve without bond. You might see that language in wills from time to time. To be an executor in North Carolina, typically you have to get bonded. You have to pay a certain amount of money to the clerk, guaranteeing that you're not going to misuse or misappropriate funds. You can waive that requirement in your will. It can create some hurdles if that person, there's certain people with a criminal history that can't get bonded. It might slow things down. I'd say typically people, if you trust the person that you picked to be your executor, you waive that requirement that they get bonded. Yeah.
If the contingent executor and beneficiaries live in another country,
Mm-hmm.
are there attorneys that we need to contact who might be familiar with the laws of that country?
So we were talking about a will that's done here in North Carolina, but there's an executor that lives in a different country. Mm. I don't think that there would be any reason they couldn't be appointed an executor still. I don't think they have to be living here in the country. I think it could create issues, just more like logistical issues, like how are they going to do this stuff? So it might be worth considering an attorney here to be appointed to be an agent, essentially. Would probably be my advice, but I don't think there's any reason you couldn't have an executor in a different state or in a different country.
Would the attorney be bonded?
Yeah, I mean, yes, if you require them to, they'd have to be.
In this state, I would.
Yeah. Okay. So you've got your documents together. You know who you want your executor to be. A will in North Carolina, you have to sign it in front of a notary. You have to sign it with 2 disinterested witnesses. Disinterested means they just can't be people that stand to inherit from you. If you've been asked to be a witness in a will, I get this question from time to time too. The witness's job is not to say, we have reviewed what is in this will, we think it's fair, yada, yada, yada. The only job for a witness is to say, I saw this person sign this will. Once you've got the document, you should file it at the courthouse, if you can. As I said, I give this presentation in a bunch of different places. Funnily enough, Henderson County is the one place I know of that doesn't let you file your will at the courthouse. Pretty much every other county we practice in does let you do that, which it makes no sense. I mean, the will is going to have to go to the courthouse anyway. Typically, I tell people, take it up to the will, they give you to the courthouse, they'll give you a little receipt. When the time comes, your executor can take that receipt along with the death certificate, get the original will, and start the process. But in Henderson County, you can't file the will at the courthouse, so you're going to need to keep it. No. Otherwise, so I would say to keep the original safe, somewhere where you know it is, somewhere where your executor knows where it is. We're going to talk about several other documents here. The will, the document we're talking about right now, is really the only one where the original is really important. You can probate a copy of a will, that is possible, but there are going to be some additional loopholes that you're going to have to jump through to prove that this document is authentic. So some people keep it in a safe deposit box. There are a bunch of different options. I would make sure somebody else knows how to get into that safe deposit box. I've had that happen before. But keep it somewhere safe. The original is important. Okay. How do I change or revoke my will? If a state changes, if something comes up, if you got an issue, you can amend a will, and that's what's called a codicil to your will. You basically have to go through the same process. You have to get a notary, you have to get witnesses. It's the whole same rigmarole. If it's a big enough change to the will, you might consider just creating an entirely new will and just revoking the old will. But the process to amend a will is called a codicil. If you're feeling a little bit more dramatic, it is also legal to revoke a written will by burning, tearing, or otherwise destroying the document with the intent and purpose of revoking it, or directing another person to do it in your presence. I get asked from time to time, does North Carolina honor out-of-state planning documents? Like if you're living here in North Carolina, but you had a will done in Florida or New York or wherever, as long as that will was legal in the state where it's created, like it complies with the laws of that state, North Carolina will honor it and will administer it like any other will. It is deemed valid. All right, any more questions about wills before we go on to some other stuff? Yeah. No, I would say not to. I do also get asked, North Carolina does honor holographic wills. A holographic will is a handwritten will. You see sometimes like scribbled on like a napkin or something, like what my last will and testament is. Those are valid in North Carolina. There are some, thresholds of authenticity that they're going to have to pass, but if it came to it, yeah, North Carolina can handle a handwritten will. It does not necessarily have to be typed. Yeah, well, I mean, probably if you're in that situation, you might not have had time to go through and gather witnesses and a notary. You maybe didn't die in front of a notary, but there are some different thresholds and loopholes that you have to jump through to prove that the document is authentic. So the power of attorney, simply put, the power of attorney, it allows the signer, whoever's creating the document, we call that person the principal, to designate an agent to make decisions concerning the principal's property on their behalf. You might have also, attorney in fact is a term that's used sometimes, but I use the phrase agent because that's the way it is in the statute. Basically, what this is you are giving another person the authority to make decisions on your behalf as though they were you. And people get kind of tripped up on this sometimes. You are not giving up any authority. You are still retaining all of that authority to make decisions for yourself. You're basically deputizing somebody else can also do that for you as though they were you. There are a couple of different types of powers of attorney. There is a durable power of attorney, and there is a springing power of attorney. Most typically what I see is a durable power of attorney. If you have one, that's probably what it is. Durable just means that it becomes effective when you sign it, and it remains effective even after you were to lose capacity. Your attending physician determines that you're incapacitated. A springing power of attorney is sort of the opposite. It only becomes effective once you no longer have capacity. It sort of springs into action once you no longer have authority to make decisions for yourself. I would say if you decide you want to make a durable power of attorney, you should be aware that, it becomes effective the moment you sign it. That person, whoever you've decided to make your agent, has the authority to act on your behalf and make as we'll see, they can make significant decisions for you. So some key information. An agent will be able to make decisions and act with respect to the client's, I'll say your property, including their money on your behalf, whether or not you're able to act for yourself. So as I said, you're not giving anything up. You still have the right to make all those decisions about your money, about your property. You're just saying that this person, who I've given my power of attorney to, is my agent. They can also do those things for me. It does not authorize an agent to make healthcare decisions for a client. We'll get into that in a minute. There's a separate document called a healthcare power of attorney that you're required to complete if you'd like them to make healthcare decisions. So think carefully and choose carefully with who you would, if you decide that you want to make somebody your power of attorney, about who that person is, and think carefully about what sort of attorney or what sort of power you want to give that agent. Because there are a couple different. There are two buckets of power that you can give an attorney, an agent. You can give them general authority, so that would include the decision to make, the authority to make decisions about real property, personal property, stocks, bonds, banks, insurance, retirement plans, taxes. I will say some financial institutions have their own sort of documents that they may require. Certain banks have their own documents they might require before they would honor a power of attorney. That's not unusual. But then there are some specific grounds or specific authority that get set apart by the statute. So things like making gifts, creating or changing rights of survivorship, changing beneficiary designations, waiving certain beneficial rights, authorizing others to act under the power of attorney, so like creating a second or like a sub power of attorney within the power of attorney, or accessing like your emails or your phone, or to act in a way that might benefit the agent. Because those are specifically kind of carved out from the statute, when you create a power of attorney, you would have for each of those would have to specifically initial, I am okay with this person accessing my email. I am okay with them acting in a way that might personally benefit themselves. Because the potential for fraud and exploitation is higher in those areas, the law makes it pretty clear you have to specifically say that you're okay with those things. There's not anything inherently nefarious about it, but just because the idea is that because the potential for fraud or abuse is higher, they want to make sure that you're very clear that you're okay or not okay with giving that authority. You're certainly able to grant some authority and withhold other authority. There might be some things you're okay with a power of attorney doing, some things you're not okay with them doing, and that's totally fine. It's absolutely your decision to make. When does the document become effective? The document becomes effective immediately. Once it's signed and notarized, it is a valid power of attorney that your agent can immediately start relying on and acting under. It remains in effect until the client dies or until the power of attorney is revoked. So a power of attorney was no longer effective after you pass away.
Does that get filed then for them, or does that just get put in the safety deposit?
Yeah, I'll get into that and what you do with it in a second. Yeah.
Is there a difference between administrator and agent?
I don't know that I've heard the term administrator. I've used the term agent. Some people say attorney in fact or power of attorney.
But it is the person, I don't know if they included that term,
That's probably an executor, is what you mean for your for your will. Yeah, a power of attorney, whatever authority you grant an agent with a power of attorney, that dies when you die. If you make somebody your power of attorney, that authority is really only effective while you're alive. Once you pass away, any power you gave a power of attorney, it goes with you. Yeah.
I have found that Social Security will not accept the power of attorney.
Yeah, a lot of places have their own like specific documents that they want before they'll accept a power of attorney. A lot of banks are like that. I think Social Security is another one. How you revoke it? You can also, much like a will, you could just destroy it, tear it up, or burn it. But you also have the option of filing a document. You might ask an attorney to help you with it, with like filing or written revocation of a power of attorney. One thing to note, probably flag, a divorce does not revoke a power of attorney naming a spouse as an agent. So if you made your spouse your power of attorney and then subsequently got divorced from that person, you might want to revoke that power of attorney, because they are still, divorce doesn't like automatically undo that. They would still be your power of attorney. And understand that it's not a will substitute. Once you pass away, any authority you gave that agent passes away with you. So it is not the same as a will. You might need them both, but you shouldn't try to use a power of attorney as a substitute for a will.
Is it good, or, I mean, is it okay if you have a power of attorney that does not live in this state where you live, or would it be better if you had a power of attorney that lived where you live?
I think it depends on what you want, why you feel like you need the power of attorney, or what you're hoping your agent can do for you. Yeah.
And then you distribute it.
Mm.
So that leaves a little bit of a loophole, but
Yeah.
you still can, I mean, I try to tell them about it. Yeah,
Hmm.
that's why I like the idea that,
Yeah. I get asked from time to time what an agent's duties are. You should know that an agent has no affirmative duty to act. Just because you've made somebody your power of attorney, they don't, it doesn't obligate them to do anything or to use that power that you've given them. However, when they do act, they have to act in accordance with whatever your best interests are. They're required to act in good faith, to act with care, competence, and diligence, to act only within the scope of authority that you've granted them. And every power of attorney is different. I mean, the forms allow for you to craft all sorts of structures and things that you're okay with them doing, things that you're not okay with them doing. They can't create a conflict of interest that impairs the agent's abilities to act impartially. They should be keeping a record of receipts, disbursements, transactions that are made on your behalf. So if you decided that you want one, you know who you want it to be, you know what you want it to say, how do you create one? Sign it in front of a notary. A power of attorney in North Carolina does not require witnesses, but it does require to be notarized. An agent, they can be anybody that you trust over the age of 18 can be your agent. And once you have it, what do you do with it? Power of attorneys, you can take those to the Register of Deeds office. And that's where it would be recorded. It's not required to be recorded, but I would say if this agent is going to be acting on this document, you should record it at the Register of Deeds office. Typically, people shouldn't need or require the original. If your agent is trying to do something on your behalf, they shouldn't be asked to present the original. A copy should be okay. But as I said, some financial institutions like banks, they have their own documents that they'll want. All right, so the third document that we're going to talk about today is the healthcare power of attorney, which is separate, different from a durable power of attorney. The healthcare power of attorney allows the signer or the principal to name a healthcare agent and up to 2 successor agents to make healthcare decisions on their behalf. The healthcare power of attorney becomes effective only when an attending physician has determined that the client is unable to make or communicate their own healthcare decisions. If the principal is able to communicate their own healthcare decisions, then the healthcare agent does not supersede them. So unlike the durable power of attorney, a healthcare power of attorney, it only becomes effective when your attending physician decides you are no longer able to make your own healthcare decisions or to communicate what those decisions are. At that point, whoever you've declared to be your healthcare power of attorney, they can step in and make that decision. I use the language attending physician, and I think if you're making a healthcare power of attorney, you should use that language as well. In most forms, you'll see they allow you to name a specific physician that you want to make that call about whether or not you have capacity or not. That is certainly your right, but it can get complicated if you've named only one person that is allowed to make that decision, and this physician is retired, dead, doesn't practice anymore, and nobody knows how to get a hold of them. It can make it very difficult to enforce. I mean, because a lot of times this is could be in a crisis situation, like a decision has to be made right now about this person. I typically tell people to just include whoever your attending physician is at the time. If they determine that you can no longer make healthcare decisions for yourself, or you at least can no longer communicate decisions for yourself, that whoever you've named as your healthcare power of attorney can step up and make those decisions.
In the state of North Carolina, is it automatically go to the spouse
No.
to make that decision?
No.
No, you
Mm.
have to have one of those.
Yeah. The healthcare power of attorney, it gives your agent pretty broad and sweeping authority to make healthcare decisions. So it includes the authority to authorize your doctor to give or not give treatment, to stop treatment, admit you to a facility, administer medications. Unless your document says otherwise, that agent's can have the same authority to make decisions about your healthcare as you would if you had the ability to do that. So I would say make sure that you talk to whoever you want to be your healthcare power attorney. If you need one, if you decide you want one, make sure you talk to this person about what your wishes are. Make sure that they know what you would want.
What happens if you don't have a healthcare power of attorney?
I mean, they would talk. They would. I'm sorry.
Not so good.
I mean,
Well, but I mean,
Yeah.
somebody's got to make a decision.
Yeah, but they probably. I mean, practically, they probably are going to look at next of kin to step up and make a decision. Yeah. I would note here, sort of like a regular durable power of attorney, if you have named your spouse as your healthcare power of attorney and you subsequently get divorced, you might want to revoke that too. Yeah. If you don't, want your ex to decide to pull the plug, definitely you want to be careful about that.
Again,
As far as that, the power of attorney, I have it where whenever you're dealing with a hospital or a doctor or something like that, they ask you, do you want all your personal information, the results of your physicals and all that sort of stuff to go, and you have to indicate, yes, my two children have the right to receive specific information.
Mm.
That's not quite power of attorney, is it? That they're getting information to make the decision.
Yeah, that sounds more like a release. They are allowed to release your medical information to these people, but I don't know that would give them authority to make a decision for you. It might be worth looking into that. Yeah.
Can one person be all three of these, the executor and the other one and this one?
For sure, and I would say that's pretty common. Some people have a child or their spouse they trust to do all of this stuff for them. I've done all three of these in one setting with people, and they want to name the same person for all of this stuff, so that's not unusual. As I said, it only becomes. Yeah, go ahead.
Oh, I just want to make a comment about that healthcare power of attorney. I think that sometimes we are reticent to look at that document and look at all the language in it and say, oh, I don't want this and this and this. But from personal experience of family members, that was so important for me to have, because how I would have approached the situation would have been definitely different from the way my brother wanted it done. And so I think, in fairness to the family members, just like you were saying about the will, this is such a critical thing because it's basically making a determination about someone's life.
Mm-hmm.
And I just want to throw that out there as
Yeah.
somebody who's had the experience, how important that is.
For sure, you're making the decision for them, so they don't have to make that decision when the time comes. You're doing everybody a favor, not just yourself. I mean, you're most of all your family. So it remains in effect, this healthcare power of attorney, until you pass away or until you regain competency. It's not, it's only effective for whatever period of time where you don't have capacity. If you were to regain capacity, then you go back to being the one that makes the decisions. Let's see. Like we've talked about earlier in the presentation, naming a successor agent, somebody is to be like a backup, that's smart, to have somebody else that you want to do it. Naming two people to do it at the same time is not as smart. This is such a charged, emotional period for a lot of families. And pick one person that you trust and knows what your wishes are, and give them the authority to make the decision. What are a healthcare agent's duties? One thing you should know, maybe to think about when you're picking the person, when you pick a healthcare agent, somebody to be your healthcare power of attorney, there's no affirmative duty on them to actually do that or to make the decisions. I can, foresee a situation where you pick somebody to be that agent, they think that they're up for it, that they can handle this decision when the time comes, and then the time comes and suddenly not so much. Like this, I thought that I was going to be able to do this, I thought that I was going to be ready for this when the time comes, and I can't. That's why it's maybe important to have a backup agent or somebody else that knows what your wishes are, because they're not going to get in trouble. I mean, even if the physician is calling them like, you're the healthcare power of attorney, we need to know what to do now, and they decide they can't make that decision, they can't make that decision. So think about having a backup.
What happens if you get the family that isn't happy with what you're going to do?
If you're the agent, I think if you're acting in the best wishes of the principal or whoever the person that's, if you're following the authority that was granted to you in the document, I try to make them as pretty thorough as I possibly can to make sure that you've got what your wishes were. I get asked too about a living will. It is technically a separate document from a healthcare power of attorney, but in my practice and in most settings, I typically include them all in one document or do them at the same time. A living will is basically your statements or wishes to the hospitals about whether you want life-prolonging medical treatment. We're talking about do you want to be on a feeding tube? Do you want to be on artificial nutrition, hydration, that kind of stuff, like end-of-life care. You should know, there's some hesitancy or concerns about filling these documents out. Whatever you put as far as your last wishes, they're going to make you comfortable within the acceptable practices of care. You'll be made clean and comfortable according to medical standards. So to create a healthcare power of attorney, how do you go about doing that? These need to be signed before a notary and two witnesses. What should I do with the document? I would say make sure that your agent has a copy. Make sure that you have one with your physician. The original is generally not required. There's a form here. I should have brought some with me. You can actually register your healthcare power of attorney with the North Carolina Secretary of State's office. There's a nominal fee. I think it's $10. They will send you back a little card that has a QR code on it, so people can scan with your phone. Your agent can pull up all your advanced directive documents on their phone. So we would think about doing that. I get asked to, I think I brought one. More and more I've been asked about the MOST form. Have people seen this? It's medical orders for scope of treatment. They're usually like this. It's like this either obnoxious pink or neon yellow kind of form. It's strictly speaking a legal document, so I would not really be involved in helping people create this. This is something you would create with your doctor or with an intending physician. It is completed with the doctor. I think the goal, they're gaining more and more prevalence. People will keep them, post them on the refrigerator, keep them in.
With a revocable living trust, can the trustee act as an agent in most applications?
Maybe I'll circle back with you after the presentation. We don't do a lot of trusts. I would say typically most of our clients, they don't really have enough assets to make a trust worth their time. But I'm happy to talk to you, like grab you afterwards, and we can talk more about it. But yeah, the idea with the most, the living will, the healthcare power of attorneys, those are documents that are created with an attorney in a legal setting. I think a lot of physicians, medical practitioners wanted something that was a little bit more like actionable, something that medical and healthcare providers could very quickly look at and figure out this is what bam, 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 this is what this person wanted. So you can have both if you want. Here I outlined some of like the differences between an advance directive like a healthcare power of attorney and the most form. The most form, that pink form that I held up, that is a medical order. It becomes part of your medical record, so it would travel with you. Anybody in a hospital who pulled up your medical record could see it there. With the healthcare power of attorney, it's generally going to be your responsibility or your family's responsibility to get that to the doctor. They're not going to necessarily know about that or have that on file. But it can only be completed with a healthcare provider. It's not something that an attorney can assist you with making, and it should be reviewed regularly. Yeah.
I just want to make a comment about that healthcare power of attorney.
Yeah.
You know, it's like with my husband, the hospital had scanned it, the doctors had scanned it. So when we went to the emergency room, they said, I don't have time to look for that. Do you have it?
Mm-hmm.
I said, yes, I did.
Yeah.
So it is kind of handy to have with you if you are needing that kind of service.
I've heard better things about the most. I mean, I think because it's a medical order, like it travels with you better than like that healthcare power of attorney. So I think they're increasingly, especially for like the emergency care, I think a lot of people want to create a most. You can have both. They can coexist with one another. If they do, for some reason, were to contradict, they're going to look at whatever was the most recent of the forms. But you can have both of them. And there are some advantages. Yeah. Yeah, I mean, it's signed on. Several different states across the country have started to adopt it, but the one that I brought, that's a copy of the North Carolina most. Medical providers across the country are kind of like, there's been a push towards a document like that. They call it different things in different states. In North Carolina, it's the medical order for scope of treatment. A lot of states have very like comparable things to this as well, though. A document that's a medical order rather than like a legal document that you would create with an attorney. This is something you would create with your doctor.
Where do you get that?
You can get it. You can get them online or go to your medical provider. Should be able to help you with one. That's kind of like the end of, do people have questions? I'm sure you probably do. Like I said, I'm also going to be around. I'm going to hang around afterwards to talk to people. If people have got like specific questions, think something they'd rather talk like about one-on-one. Thank you so much for coming. I really appreciate the opportunity to talk to people about Pisgah Legal Services, about the work that we do. Love to come back if people are interested in another topic like elder fraud, scams, that kind of stuff. That's a really interesting topic. Oh, absolutely. I'm glad that it helped. If you need an attorney, if somebody thinks, if you think they would benefit from talking to an attorney, call Pisgah, apply online. There's no harm in applying. And we do a lot, everything short of criminal law. We probably either do it or we know somebody who does do it and can try to connect somebody. So I would say tell people to call. It's not going to, all we can do is say we can't help. Yes. All right. Yeah, I can email you. I can email you the PowerPoint now if you'd want. Yeah.
If you need an attorney, does Pisgah have a list of attorneys?
We do. We have a list of private attorneys in the area. If for some reason, like there was a conflict or you didn't qualify for our services, typically we would refer you to a private attorney in the area. Yeah.
Do you have some specialized in this?
Yeah, we definitely do. We have the Elder Care Advanced Directive stuff uses a lot of we call it the Mountain Area Volunteer Lawyer Program, our MAVEL program. That's like our pro bono network. We refer a lot of people to private attorneys to help them with this stuff.
I have a question.
Sure.
There are some people that I'm thinking of Orman. Susie Orman. Are you familiar?
Yeah.
Who doesn't know Susie?
No, I know, yeah.
She sells this whole packet,
Mm.
and, online for like $60, or it's a nominal fee. What's your take on that kind of stuff? Do you think that if you fill it out, I mean, her idea is to help you prevent, spending a lot of attorney fees.
Mhm. I d-
I'm just wondering, we
Yeah.
didn't, obviously, we didn't do it, but, you know, you hear about these and you don't wanna.
I don't want to like unfairly disparage Susie Orman. I don't like. I don't know. I'd have to look specifically at it. I don't know. I mean, I'm all for people getting their affairs in order and not like spending a lot of money to do it. I mean, I think everybody would benefit from at least having a simple will, and it shouldn't be something that's like prohibitively expensive either. So I'll have to take a look at it. Yeah,
And then I
yeah.
just had another question. I know you said that the wills from other states can be pretty much used here in North Carolina. What about the health power of attorney? Does that vary from state to state?
So certainly with a durable power of attorneys, there's been a push to sort of like called the Uniform Power of Attorneys Act across states to make them pretty much identical. North Carolina is one of those states where, I mean, if you pull up a power of attorney, it's pretty much like directly drawn from the statute. Almost all of them look the same. But typically, as long as it was valid in the state where it was created, it should be able to be followed here in North Carolina.
But the healthcare piece of it,
Mm.
Does that change from state to state? Do you have a?
It shouldn't.
It shouldn't.
No, they're pretty standardized. Cover like the same stuff. So no, it shouldn't be a problem. Yes, ma'am.
Another comment I have about
Yeah.
like a healthcare power of attorney. I just feel it's really important that you have a really good discussion with whoever has been named
Mm-hmm.
about how I really feel about it.
Mhm.
I think it's important that they truly understand what I want. And if it comes down to a difficult decision, if I said this is what I want done, it's okay.
Yeah.
To do that. I think that is so important because we do this, but then we don't talk in, pretty thorough conversation about what our wishes really are.
No, you can make it so much easier for your family if they know they don't have to worry about like, is this what she wanted? I don't want to make the wrong choice here. If you've done that work for them, you're going to save them a lot of stress and a lot of heartache, and it's already a miserable enough time. You don't need to make it harder. Like make these decisions. It doesn't even take that long to create a lot of these documents. You need to take an afternoon, and you can save a lot of heartache for your loved ones when the time comes. Yes, ma'am.
I was just going to comment on the reason we should have wills.
Mm-hmm.
Several years ago, I worked with a client. The mom, dad, and adult daughter died in an auto crash.
Mm-hmm.
Daughter was dead at the scene. Mom died on the way to the hospital, and dad died at the hospital. And they had no wills, so then it was, it ended up with dad's relatives and trying to track them down.
Mm-hmm.
And the distribution can be just totally opposite of what you would ever want to have.
Mm-hmm. Yeah, absolutely. I think it's never too early to start thinking about this stuff, and just like you can always update them, if the time comes, but like get something on paper.
Thank you.
Oh, absolutely.
And my friends were right about you.
Oh, good. I'm glad. Good. I had a lot to live up to.
And Casey is sending